center of this document, that's all that counts.
Did you have something?
Whatever the board would like to do, we sound that here to assist, not looking to make it more difficult, but as I said,
No,
I know how long you
think it's
focused on
helpful.
this and how important it is to you, and I wanted to tell you that. So whatever the board's pleasure is, we're here to assist in any way that we
Well,
can.
I mean,
We
at this,
appreciate
at this point, we've had 22 rejections. And
And
I would think that those rejections, from that standpoint, Ray, if there are additional signatures that we haven't viewed, we should review them with regard to those 22. I mean, the other ones that we've already approved, we've approved them. So
That's right. If it's
Especially if
been,
the vote, if it's a close right now.
Yeah.
Well, could we at this point take a 5-minute recess because some of us would like to have that time.
Oh, I was gonna come over there.
Oh, my God. Yeah, I'm gonna be here for a while.
Yeah, exactly.
I mean, just out of the 21 that we've rejected. Right, so is there, I was gonna ask you, is there an urgency to have this? Can we talk with that number? State, he's gonna give us. Angel, can you? You're here for the Secretary of State, right? So is there any valid issue if we go back? Because my concern is now, because he's only right, because he's only a few short. I don't want to put your office. Oh, okay.
I would never think that there's only one place.
Yeah, I saw you moving around in your seat. That's why I was going to get you up.
We have most of them.
No, they should, yeah, you should.
That's a good question. Probable successor.
So when you do it, some of them were, they were.
Yeah, that could. I have a feeling. Yeah. We do.
I don't think that's
The guy in the check.
We should notice.
I know, yeah, I get
So it's good. Another board.
Apparently, and I noticed this the last time. They gave us printouts.
Yeah.
The printout had sometimes 3 signatures instead of one.
I like that.
So, well, because you may have signed one way here, one way
Absolutely.
there. So.
And when you're in a restroom, sign.
What is now, Angel just told us that Secretary of State office can provide us with
Those.
all of the signatures. So,
Mm.
so for example, your signature,
Yeah,
there may be
Absolutely.
4 of yours. there.
Yep.
And we
On
look at all 4.
DMV, everything else.
Particularly with regard to the ones that we reject.
I agree. I think they, especially because he's really close. I agree. I think that'd be a great idea.
I think if we do, I think Ray's gonna talk to them about basically continuing it.
Yeah.
To our.
So that we
meeting,
can
so that
provide all the
they can
samples.
provide us with all of
Especially
them.
like there were some that we were like,
Right.
yeah, that felt like really crappy to
And
reject.
they're close now. I mean,
Okay.
he's within 15 now, I think.
Hopefully he agrees. Like he
Oh,
would
I
be
mean,
a fool
I'm
too.
sure he'll.
Yeah.
The only issue is it holds him up a little bit. Oh, I'm sorry.
No, you're fine. Don't say, no, I want to
It
stand.
holds him up a little bit, but the election's not
He
till
doesn't have
November
a
anyway.
primary.
Right. So apparently, Angel says that there are, the last time we had like more than one signature.
Yeah.
So we're gonna have the secretary get us
That's great.
the signatures out of the system, so that maybe on some of these we reject it if there's, because he's close, he's only about 14.
You know what's gonna happen. You know the handbook guy, the secretary said, oh my God, you both weren't here when this was happening. This dude got like 400 of his signatures rejected, and I think he's here again to like contest some of it.
Oh, yeah.
He's running for the Democratic Secretary of State.
We still. Did you see the next one? Okay, so we should order.
We should order two. He
I
doesn't
don't
have
know,
enough
I don't
signatures.
know,
Just hand me
if
the
if
water
they're gonna
bottle.
give us duplicate signatures,
Right.
I think Ray's gonna suggest that we move the other one too. I
Crap,
think,
it's gonna go.
oh, I know,
Is it-
I know.
How much money?
I told him to wait for the-
But I think that's what's gonna happen. Let me give you a seat back.
Okay, you're good, you're good.
He doesn't have enough signatures, even if we revise them, he doesn't have enough signatures.
Oh,
That's the thing, he doesn't have enough
I
signatures.
just saw the bottom part.
On these nominations, on these nominations, I'm inclined to allow everything, because like the site that this report like that, I mean,
Absolutely,
if
and
you
I
gave it to
agree.
me, if you came up to me and two
I-
months and said, will you sign my nomination? You would sign it.
Yeah.
Yeah,
And the whole print thing.
Got it.
We
Oh,
all.
okay.
I know, I do that too. I was
oh, thank you. Okay, yeah, it was just, I was like, because half of the time I couldn't find them, and I was like, did I read the wrong name? Thank you.
I always say,
Yeah.
write that down at the end of the day.
Oh, got it. No, I appreciate it. I appreciate it. Awesome. Thank you so much.
Even if it's my account, I'll sign it. Okay, yeah.
Yeah, same.
I'm not.
Same.
I can't be, because I can't be bothered. I leave stuff blank.
He's
You
like,
didn't put the date in, you didn't
He
put
has
this in,
no
you didn't write anything.
To that
Okay,
kind of-
right.
I also do love that people write their name completely different, that
Yeah.
like it's in their actual voting record. Like, no, but just like, your name is Jennifer. No, it's Yennefer.
yeah. One of them was like Jeremy,
But
J.A.
then
and then
some of these, you don't know when they were signed.
Yeah,
Because
that
like
is
when I
true.
registered to vote,
Yeah.
my signature doesn't
And
look
we
anything
don't-
like it
yeah.
does now.
Yeah, and I'm trying to remember, I registered to vote at the DMV, I don't remember. Because then when I moved,
And then some of them are on pad.
yeah, which is
Stylus.
terrible. Yeah.
Now sometimes people are doing it with their finger.
Yes, I look like, yeah,
Let's reconvene.
perfect. Okay. So we can get going.
did you have to cancel your meeting?
I just told the co-chair, I was like, if you can do this, do it.
If not,
Yeah. Fuck.
Okay, we are reconvening this meeting of the State Board of Elections at 5:10 PM. I think we've heard a lot of information from Attorney Tavares and others, and I'm thinking that we may want to take an action at this point that would give us some time to have the review. Mr. Reposa, do you have anything you'd like to say at this point?
My suggestion to the board would be to suspend this afternoon's agenda item number 7 until next Wednesday. That would give the staff additional time to go into the CVRS to look at the different additions of signatures that may exist, and that we address Mr. Gizarelli and Rihanna both next Wednesday at 2
Is your
PM.
mic on?
It is.
I'm looking at Mr. Hunt, and he has a look of exasperation on his face, but I mean, you will agree that we need to be thorough here
I-
to
I
make
am-
sure that,
We're trying to.
I completely understand. I appreciate the thoroughness of the board very much. I just do want to point out that I did provide this list, comprehensive list with all these names I would wish to review in plenty of time for this meeting, so it's a little disappointing. I also am expecting my son on Friday, so Wednesday is going to be very difficult to get to work. So yeah, I don't know what to say. I would actually just like to add one other comment too. During the course of reviewing these signatures and talking to numerous town clerks, and I'm not sure if anybody's here that can back this up, I would also like to point out that the town clerks regularly use these voter petitions to update voter registrations when they find that someone signed with an old address, and that is common practice amongst them to keep their voting records. I don't think it's very fair that the Secretary of State is using our efforts to update their voting rolls and then not giving us credit for those same voters. So I'd like that to be taken into consideration when the board makes their decision about accepting these remaining signatures. So thank you.
you've made a good point. Do you have something to say, Mr. DeSimone?
Yeah, except just so that Mr. Hunt knows, one of the reasons for the suspension was brought to us by the Secretary of State's office that they could provide us this information. So they are going above and beyond, so to speak, in this regard. So Attorney Tavares has been kind enough to do that. So I don't want to have anybody, I don't want anything to seem critical of the Secretary of State's office, because they're the ones that actually have brought our attention to this. So
That's true.
with regard to the denials or the rejections that we've given you on your nomination papers, you're actually getting a second bite at them, thanks to them.
Thank you. I appreciate that. And I very much appreciate that. Thank you.
Well said. Yes, Mrs. Johnson.
Just on the timing, so we're not talking about could we see the additional signatures today? I understand it's, past 5, or are we going to comprehensively look at more than we could possibly today, gain access to today? Does that make sense? Probably
I
not.
believe that we need time to
Okay.
go in and do the research that
Okay.
we would not essentially be able to
Yeah.
do today, because we actually have 2 candidates now to go
Agreed.
in and do that research.
Yeah, and then, okay, go ahead.
No, go ahead, go ahead.
No, I
I'm
was
sorry.
just gonna say is there, Mr. Hunt, with respect to your family situation, which I definitely respect, is there a way that Mr. Gizarelli could make time to be here?
I will do my best to either myself appear or have the candidate appear for sure, certainly.
Thanks.
Madam Chair, the only other question I have is, we're going to see the different variations of the signatures, right? We're not
That
just
is
gonna
up.
see
That is-
one.
that is
Okay.
what we are planning
Okay.
on delivering to the board.
As well as Mr. Hunt, he would also have access to that.
Mhm.
Is that we can, and I think Mr. Tavares said they're going to make efforts so that we can have copies of those papers so that the candidates can see them too. Or if you give them to the board, then we can just make copies for the candidates.
Right.
Just so that I can be heard, yes, the one thing that we will need, because this has been before the board, will be, and we'll work with the board and also Mr. Hunt and the other candidate as well, Mr. Rihanna. We just need to know which names we're looking at.
Yeah.
Right.
As we know that, we're happy
Right,
to
because
print out.
we've
so that each
accepted a
name-
lot.
We'd have.
Was it?
We've accepted
Yeah.
a lot of those
Right,
signatures.
which is the ones
Correct.
that have either been rejected or still outstanding.
Right.
You can have the multiple.
Perfect.
And will that be enough time to have everything generated and have the candidates review and have a hearing by Wednesday? Would that?
We're gonna work on and help in any way that we can, but we certainly, today is it Tuesday?
Tuesday.
Back 2 days.
We should be.
But I would expect that they would have this by Thursday, because the number that we're talking about is a pretty small subset, but we want to make sure they have all the signatures.
But you also have both candidates.
Right, and this is for both candidates we're talking about, though, Mr. Tavares, right?
You gotta remember, I'm in the middle of the primary.
Okay,
Yeah.
so did you have something else,
No,
Mr.
no, that was
DeSimone?
it.
Do we have an action that the board would like to take at this time?
Madam Chair, I think the motion would be just for one candidate at a time, because I don't know if I didn't have time to get confirmation as to whether he would agree to a continuance or would want to press on
Okay.
because he would want to possibly campaign.
Okay, so we'll take up the first. Mr. Gizarelli, correct?
I move we suspend the meeting today and continue it to next Wednesday.
With respect to Mr. Gizarelli?
Yeah, with respect to Mr. Gizarelli, correct.
Second.
So we will reconvene on this matter next Wednesday. Is it 2 o'clock,
Yes.
2 PM? Motion made and seconded. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed? It's unanimous. That's August 24th.
Thank you very much.
Thank you. With reference to the next matter, Mr. Rihanna,
Hi, how are you?
And
you've heard our discussion, so go ahead, Ray.
do you have any opposition to having the matter continue so that you can have access to the information of the possible additional signature comparisons, specimens?
Yeah, I'm not trying to be rude or disrespectful, but I sat here for 3 hours. For 3 hours. I'm a healthcare worker. My schedule varies. I work 12-hour shifts. So I don't get to pick and choose my own schedule. So and I don't get I get my schedule weekly. So I don't know what Wednesday holds for me. So I can't give a definite answer. I had to switch my schedule to be here today.
That's true.
So it's kind of, upsetting that I have to wait another week just to find out. And why all the candidates that got on the ballot are campaigning, I can't even campaign because I don't know if I'm on the ballot. So what sense would it make? You know what I mean? I'm losing time, just like the Libertarian candidates losing time. We got to get out there and get our voices heard. And we're small. We're independents. We don't have, the big money, the big TV time. We don't get noticed in media. As you can see, only Pat Ford from the Coalition Radio's here, but no one else. So we don't get that fairness in elections. So obviously I have to take it because I want my process to go through correctly and be fair. My total says 1,189. It should be 1,219 from what I have here. But that's another matter. I don't know how they're gonna handle that. Also, a paper in Coventry is missing. I called the lady 3 times. She said she don't know what happened to the paper. They'll look it over. The paper was a full sheet on the front. When I did go in there, she didn't like me anyway because of my whole vaccine stance. That's none of the board's issue. But she was very unprofessional when I got there. She couldn't give me a copy because it causes taxpayers money.
Well, is there a form number you're referring to?
I don't have the phone number because, like I said, we're very small. I had to try to make it to 39 cities and towns with 2 people.
Mr. Rihanna, would you like to give us a preferable time or date? I mean, is that,
I can call Mr. Raposa and, try
because
to
we
figure it out.
understand the work situation and
Yes.
we might be able to accommodate you.
So, yeah, I can definitely, like I said, try to continue it and call Mr. Raposa. And we can figure it out through there. But, this is hard enough for independents and libertarians as it is. And it just seems like it's getting harder. We appreciate what you're doing, giving us a chance and time. But, we have to get out there and campaign door to door. We don't get these big TV commercials.
I get it. The clock is ticking.
Yes. But,
Okay, so we, with your permission, then we'll continue this until such time as you can be present.
Yes.
And we'll make that as soon as possible with all of the parties involved here.
But also, can I say one more thing? There's a couple people here. His wife signed. His wife can't make it. Her father signed. He couldn't make it. Actually, my girlfriend's father. There's certain things. And then I also brought someone in here the other day with you named Angela Offes Burton, and they said I had to wait for the hearing, but everyone has different work schedules. I can't just tell, all 42 people, hey, be here on this day and take your day off. Bad enough we're down short staff with workers as it is. Imagine having 42 of them here.
I understand.
If you have people here today
Yeah.
that are going to attest to their signature, we We can let them do it now. I mean, I don't want to
Only
bring
one.
them back.
He's here for his wife and she's here for his father. But
And,
they're
and
not,
did they sign in their presence?
the father signed in her presence.
Yep.
And signed it, and the wife signed in his presence.
Okay, and they're going to testify to that
They
today?
can.
Madam Chair, I would move before we continue to have them at least
Make it part of the
make
record.
it part of the record
I
that we
agree.
can approve those signatures.
So
I
they won't have
appreciate
to
that. Thank
return.
you so much.
So we need to have those two step forward, and I know. Is there something that we can ask them on the record?
And there's also one more person that can verify somebody else.
Okay, well, we'll need those signatures, right?
Yeah,
On
if we
those
could have the
sheets.
form and line number, that would be
help
helpful. Miguel,
pinpoint
I don't
the,
know if
yeah.
that's, if you can even do that.
That would be helpful, but we could look it up by the name as well, I believe so.
Can we recess while that's not recess, but maybe take up something that's
Sure.
quicker while they're doing that work?
Thank you so
Want
much.
to
I
go to the
appreciate
next
it.
item?
Yeah, that would be helpful
Is
to
there
have the
anything that
form
we-
in the
we
line.
could-
No, you can go to the next item,
Yo,
Miguel's
Miguel, is that
working with
possible?
them. And then Ray is number 7.
He's going to get us the form number in the line. That'll make it easier for us to.
That would be
track
perfect.
back.
Yeah.
Should we go to number 8? Is that
Number 7.
number 7?
Miguel, can you
Right,
take
right.
them in that other hearing room? Because we're going to go
Yes,
to
of course.
7, and then you can come back after you have.
Absolutely, yes.
Perfect, thank you. So while they're getting that information for us, we're going to take up item number 7 on the agenda. Item number 7, the board may discuss and vote upon the implementation of a system for the electronic delivery and receipt of mail ballots cast by eligible disabled voters. Mr. Marcaccio? can you
Yes,
address
Madam
that?
Chair, thank you. During this last legislative session, certain sections of Chapter 20 were amended, including Section 6.1 and Section 9, which I believe you have a copy before you. And if you look at Section 9 under subsection C, so this would be the third page of that document, you will see that subsection C was amended to allow eligible disabled voters to be entitled to electronically receive and return their mail ballot using the same electronic transmission system as that used by voters covered by the UCAVA, the Overseas Act. This electronic process shall satisfy the Federal Rehabilitation Act, Section 508, concerning accessibility standards. When the General Assembly passed this legislation, they did also modify 6.1 to require the implementation of an electronic system through the Secretary of State that would meet certain cybersecurity standards. And those are specified on page 2. However, looking at Section 9 standing alone, there still is a mandate here, and there still is an electronic system that exists now, even prior to the modifications that will be done, but have not been done yet, as I understand it, by the Secretary's office. So whatever electronic transmission system that we currently use for overseas voters should be adopted for those who are eligible disabled voters. And as that system may progress over the next election cycle or whenever, their rights and access to that system would likewise follow. But right now, whatever we do have in place should be provided to the disabled community in accordance with Section 9. I believe, and the staff can clarify this if needed, but I do believe that the way that the overseas ballot is cast now, that electronic system can be done in a way that, for example, can be paperless, so that if somebody were in need of filling something out, cannot see a piece of paper, they may be able to do so with a screen in some fashion. And I don't know if anyone here from the staff needs to.
I would think that Rob, you can talk to this part of number 7 based on the C is how we process those, correct?
Thank you, Chairman and members of the board. Rob Rock from the Secretary of State's Office, and actually Attorney Marcaccio explained it, I think, very thoroughly, that we do have a system in place for the UOCAVA voters, the military and overseas voters, to provide their ballots to them electronically. The board made a decision back in 2020 to allow the return of the ballots via email, and with the new legislation, voters with disabilities would be allowed the same access to that return of mail ballots. And because we do have a system in place, you also have a system in place for the return, a secure system with the designated email address, that we feel that the voters with disabilities would have access to the same system that military and overseas voters currently have and have had for quite some time.
Okay. Thank you, Mr. Rock. So what action does the board need to take at this point?
Well, I think the board should, if it agrees, it should move to adopt and use the current electronic system implemented for overseas ballots and allow that for the people who are disabled, who are eligible under, as disabled citizens, to vote in a similar manner.
Does the board have a motion to that effect?
So moved.
Moved by Mr. DeSimone. Do we have a second? Seconded by Mr. Scholes. Any discussion on the motion? Mr. West?
For people out there in the public, to make sure that this system is definitely a safe system, that there has been no problem with this system since it's been installed,
Yep, good point.
and it meets all the criteria of, what could I say, the security of the, that we, let's put it this way, the highest level of security that we have that this
It's in place,
particular
yes.
form of transmission means.
Good point, Mr. West. Any other discussion?
I just have one question. before
Yes,
we vote
Mr.
on it.
Scholes.
Perhaps Mr. Rock could answer the question. When the electronic vote comes in, where does it go? Does it go to the Secretary of State's office, or
It comes
does
here.
it come to the board?
The board has designated an email address for military and overseas voters to send their ballot back. And
Comes here. So the board has the access to that email?
Yes, sir.
But not the Secretary of State?
that's correct. We send the ballot, you receive it.
Okay, thank you.
Yeah, as well as a facsimile number too. Is that still in operation?
It is a possibility, but it is not used, I'm
Yeah.
gonna say, not even remotely. Most of
It's
them are
kind of
email.
obsolete right now, right? Fax-
It's
fax
obsolete.
numbers.
I should have it disconnected.
And just one other question, Madam
Yes.
Chair, Rob, while you're here. And you're confident in the current system and that the current system will accommodate the disabled voter as well as the UOCAVA voters?
Yes, so much so that the voters with disabilities are actually able to mark their ballot using an assistive device if they're unable to mark it with a pen and paper.
Excellent.
Thank you.
Absolutely.
Okay, so we have a motion and a second to adopt and use the electronic system. Do we have any other discussion or questions? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, it's unanimous vote. Okay. Should we wait another minute or so before moving on, do you think?
We have number 8 too, right?
They sent it today. The directive?
Yeah.
They sent it today.
So the record for the one canvas to remain open?
Yes. That's not it.
Yes,
It's the 4 o'clock that they were concerned about.
Right.
Election day special.
they keep it open.
Yeah. So you're suggesting we take that up? Is that what
Why
you're
not?
saying?
That's- Bob can make the presentation.
Yeah. Bob, we're going to take up number 9 at this point,
I was,
because it should be pretty straightforward. The board may discuss and vote to issue a directive to all boards of canvassers to remain open during their regular business hours for all Title 17 elections during the 20-day emergency period until 4 PM the day preceding any Title 17 election. Can you please explain?
Board members, in 2020, you did a similar directive to the local boards. And what I'm asking today is for you to discuss and issue a new directive that would be effective not only for the 2022 elections, but also going forward, which would help the local boards to realize that they need to be open during normal business hours to accept emergency/early voters coming into their facilities. I have had conversations with some of the canvassers that did not want to be open during their normal hours. They wanted to open a half an hour late in the morning and close a half an hour late in the afternoon. And they're disenfranchising voters. And what I'm looking for you is a directive that will require them to be open during the hours that their offices are open. Because
Yeah.
voting doesn't happen every day, but we are public servants, and it is our job to be offering the early voting to the voters when they come in. And that's why
I agree, and I think we need some uniformity as well. If citizens are used to going to their town halls at a certain time and they're not able to vote when they think they can, you're right, it'll turn them away and disenfranchises the word.
Well,
So-
an example is if let's say there's a town hall that I'm a resident of, open till 4:00. I get out of work early. I get to the town hall at 4:20, and they tell me I can't vote because they ended early voting at 3:30. I'm disenfranchised. And
Yeah.
why? It's only a 20-day period. It isn't something that we do every day of the year. It's only the 20 days preceding an election at election time for a Title 17 election.
And I have a feeling that the clerks would agree with you that that's how it should be, for the most part.
Yes.
Yes,
Can I
Mrs.
ask a
Johnson.
question, Bob? Because I remember talking about this, but is there, when you say normal business hours, what hours are they open?
Not
What is
all,
normal business hours?
not
Are they
all
different?
39 have the same
No,
hours. Some
they don't.
open at 8:30, close at 3:30, some open at 9, some close at 4. So there is no commonality amongst the
That's
39.
true.
But what this directive would require them to be, would be to be open to accept early voters during the time that they are open.
So for the complete time the town hall is open. So if the town hall opens at 8:30, they need to stop allowing people to vote at 8:30.
Yes,
And if they close on a Friday afternoon at 2:30,
they close at 2:30 because that's their normal
Well, and
business
the
hours.
residents know that, right?
And the residents
Right.
know that.
because
You have
Thursdays they're open till 6.
Right, they stay open.
So
And,
Extra
and the,
hours.
and this directive also mirrors state law that the very last day, the day before an election, they can only accept early voters until 4 PM by state statute.
So is that why
Did you
4
have
PM is here? Because you mentioned some of them close at 2:30, so I
Yeah.
was very confused as to why it said
4 PM, I believe it states on the last day.
So it just says during the 20-day emergency period and on to, the day preceding?
The day
Ah,
preceding.
got it.
Because
Okay, sorry.
that's when
Thank you.
early voting
Just for
is.
that deadline.
Just for
Got
that day.
So
Thank you.
regardless of what time so if, for example, their normal business hours were 3:00 on the day before voting, they have to allow it till 4.
That's true, because that is state statute. That is something that
Correct.
you don't
That's
have,
uniform.
you don't have the flexibility to change.
Okay. So do we need an action by the board to send this directive to our local boards?
Madam Chair, can I ask one more
Sure.
question? Sorry. Bob, well, two things. One is how, I'm concerned about confusion on the part of voters when we say early voting. Is there a plan to basically reinforce with residents that this directive is happening and that cities and towns will be open, their regular business
And the-
operation hours?
Yes, and the
'Cause-
cities and towns are responsible for publicizing when they are open
Right.
for early voting.
No, I understand, but are we providing guidance and directive around how to message that, because
Yeah.
I know that also can be all over. And then my other question is, what about weekends?
There is not a limitation on weekends. If they want to be open, a city or town wants to be open on a Saturday or a Sunday or Thursday night till 6 o'clock, or Monday night till 4 or 5 o'clock, there is not a prohibition found in state law that would prohibit them to do so.
Yeah, I just think it's important that people know so they can plan ahead what the
But again,
changes will
and
be.
I agree, but that is something that is individual based on the Board of Canvassers, and it would be up to them to notify their residents, however they do. Some of them do robocalls. They let people know what is occurring in their town. It would be up to them to notify. I personally think if they want to work a Saturday or a Sunday or stay open to 6 o'clock, it's another step that they're taking to provide this service to their voters.
Mhm.
But this is just, through the chair, this is just basically your basic operating hours. That's when we want you there.
That's all this directive
Yeah,
covers.
that's the
You
minimum
are-
requirement.
That you are open during your normal hours.
Okay. Which action would the board
I
like to?
move that we direct the executive director to issue the directive to the local boards of canvassers as presented in the directive.
So we have a motion by Mr. Schultz. Do we have a second?
Second.
Seconded by Mrs. Johnson. Any further discussion or questions? Okay, hearing none. All in favor signify by saying aye.
Aye.
Those opposed? It's unanimous. Thank you, Bob.
Thank you.
Now we have the executive session.
Number 8.
Yeah.
We didn't do number 8, right?
Madam Chair, as you, and members of the board, as you know, Miguel Nunez worked with Paul Rihanna about the people with the names. We have the names. There are people here that can attest to the names, but the individuals that actually signed this paperwork are not present at 2000 Plainfield Pike.
So what does that mean for the testimony?
Well, who is here? I suppose if the board is considering opening up Mr. Rihanna's matter, then we hear from Mr. Rihanna as to who they are and why he thinks they would be the relevant information. I can't answer that without hearing from him.
Okay.
So that's up to the board if you want to
Okay.
begin that
Understood.
hearing.
Sheila is his wife.
Can you turn the mic on?
Sorry.
Oh, you're good.
I think it's on, but he
No,
has
it's
to.
not. It's not on because I don't see the little green light. One more time. Oh, no. There you go.
Ah,
Can you hear me now?
Who is he?
Thank
Yes.
you.
Just like that.
Sheila is his wife.
Could you give us the first name of the signature that you're discussing?
Sheila McDonald. North Providence.
She is on Form 91, line 5 in North Providence.
And who did you say is here for her?
Her husband.
So, I think it'll be fairly simple to swear him in, let him look at the signature and ask if it's his wife's signature, and then we can take that for probative value, I think. Correct, Ray? And we can look at it and say, well, okay, does he know what to be his wife's signature on these nomination papers? Was he there?
Yeah, he'll be under oath if he attests that that's his wife and that's the signature.
No.
It may not be the best evidence, but it is
evidence
evidence of
The
it.
chair will swear you in.
and that will be just additional information we'll have when we're reviewing the other signatures.
Right, we can either do that now or.
Well, we'd have to make
Or
them
we
come
can-
back, so
yeah,
let's take the
but At
testimony
least he
now.
doesn't have to come back.
So can you raise your right hand, please? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Right.
Very good. So-
Sir, the director's going to show you a signature on a nomination paper.
And can we identify the form number and the line just so that there's a record of this?
And your name again, sir? We didn't get his name.
Joseph McDonald.
Is that Form 995?
91, line 5.
91, I'm sorry.
Yep.
This is,
I'm assuming he's going to say my wife signed it and I was there, but I mean, I don't know.
Yes, that's her signature.
Well, let's hear from the witness. Go ahead,
Her
Mr.
signature.
McDonald.
So you're attesting to the fact that that is your wife's signature
Yes.
on that form?
Yes.
Were you present when she signed it?
Yes.
And is that your address?
Yep.
I mean, Madam Chair, if it's not out of order, I would move to approve Form 91, line 5 as a signature, Sheila McDonald.
So we have a motion by Mr. DeSimone, seconded by Ms. Bettencourt to approve that signature. Any discussion? That's based on the testimony provided by the witness. All in favor signify by saying aye.
Aye.
Those opposed? It's unanimous vote. Her name? Mr. McDonald, what's your first name again?
Joseph.
Joseph McDonald.
Thank you. Oh, yeah, his name is Rhode.
The next, please. Thank you, sir.
The next one is Kara Tibbetts, and she's here validating her father's signature, Kevin Tibbetts.
Kara, would you raise your right hand, please? Do you solemnly swear
Form
the testimony
46.
you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
And could you state your full name and your address for the record?
Kara Tibbetts, 322 Station Street, Coventry.
Thank you.
What's the form number?
Form 50, and it is line 9.
Got it.
So yeah, that's my dad, and I got that signature from him.
Did he sign this in your presence?
He did, yes,
And do you recognize that to be your father's signature?
yes.
Any questions of the witness?
One question, is that your signature on the nomination paper?
Huh?
And page 2? Did you sign that affidavit?
I collected them and I got them notarized, yeah. If that's what you're asking.
Yes.
Yeah,
Sorry.
that is what he's asking.
Thank you.
Okay,
The third individual.
Well, I would,
Hold on a second.
I would
we're
move.
going to take an action on this one. Go ahead.
I would move approval of that signature on line 9,
I was also involved with.
based upon her testimony.
Right, do we have a second to Mr. DeSimone's motion?
Second.
Seconded by Mr. Schultz, any
That's her
discussion?
neighbor.
Hearing none, all in favor signify by saying aye.
Aye.
Those opposed? It's unanimous to approve that signature. Thank you.
Members of the
Next.
board, the third individual's name is Caleb Bake, B-A-K-E-D.
We have a different one up there.
It is Form 46, and it is line 8.
Thank you.
Caleb Baker? Is that, are you going to testify on
So
that?
that's her neighbor and I was with her and
Okay, so you
she,
also,
yeah, we had like a
Oh,
little
it's the
team
same.
of people that were
so
helping
you also
pull.
witnessed the signature?
Yes, I did.
Any questions of the board members?
And do you know that to be Mr. Baker who signed this document?
I don't know him personally. Like I said, that's her neighbor,
Then
so
I think you'd hear from
can't-
that witness.
Okay.
Yeah.
Thank
Do you
you.
mind coming forward, please, and being sworn? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You do. Your
And
name
can you state,
address.
yes, please.
Your name.
Joanne Liberty,
And your address, please?
110 Woodland Drive, apartment 115 in Coventry, Rhode Island.
Thank you very much. Okay,
Do you recognize this signature, ma'am?
Well, from the paper, I saw him sign it. I was right there.
And what gentleman did you see sign it? What's his
Caleb.
name?
Caleb. I think it's Baker or Baker. I can't remember. Yeah.
And did he sign it in your presence?
Yes.
And you recall that?
Yes. Yes.
Just one other question. And you recognized him as Caleb Baker?
Yes.
Okay.
Again, I would move approval of the signature on line 8, 146.
Based on the testimony given.
Again, based on the
Mr.
testimony. given.
DeSimone made a motion. Do we have a second?
Second.
Mr. Scholes made the second. Any discussion? Hearing none, all in favor, signify by saying aye.
Aye.
Opposed? It's unanimous to approve that signature.
Thank you, everyone. I hope you enjoy your night.
Please stay.
Thank you, Bob. Number 8.
I do, for my file, I do, but I don't think you have to. I hope so. I will. Right, maybe we should leave them right here.
Okay, because Ray is going to address them.
Oh, okay. Yeah, yeah.
You never talked about that.
Mhm.
Item number 8.
Number 8, right?
Number 8.
The board may hear and vote upon a complaint filed with the board by Anthony Tamba on August 10th, 2022, requesting that the board reconsider its vote taken on July 25th, 2022, regarding the nomination papers submitted in support of Mr. Tamba's candidacy for the office of Secretary of State. Mr. Tamba's here, I know that, he's present. He's been here for quite a while now, as we all have been. I'd like to swear you in, if that's okay with you. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you very much. Your name and address for the record, please.
Anthony Tamba,
And your address?
48 Buckland Street, Pawtucket.
Very good.
Madam Chair, if you wish, I can at least frame the issues for the board and then
That would be very helpful.
provide it to the board for consideration. Present before the board is a filing by Mr. Tamba dated August 9, 2022, which was filed with the board on August 10. The filing is fashioned as a complaint by the pro se person. And upon reviewing it, it really is, in sum and substance, a motion for reconsideration. While you're not covered by the rules of procedure in the Superior Court, they are nonetheless a good guidance for you. And for the board to consider a decision that it already rendered, in this case on July 25, there should be some criteria that are considered and met before you actually hear evidence on the actual petition or the motion. For example, if the moving party comes before you and can establish that this is newly discovered evidence that he did not have or did not have access to, or can establish excusable neglect, then it would be ripe for the board to review that former decision, in this case from July 25. The corollary is equally true. If the evidence was in the possession of the moving party at the time that the board made its decision, regardless of whether you considered the evidence, but if it was in his possession that he could have proffered to the board, then in my judgment, in my opinion, it would not be ripe for review because he would not be able to show that it's newly discovered evidence. And I think we can hear from Mr. Tamba and from the staff so that you're assured that the evidence he would attempt to present was information he had in his possession at the time of the hearing. However, I do note that looking at the four corners of the filing itself, you will see that he references form number 2, page number 2, and asserts that a number of signatures should be added to his total because they were either rejected or in some other way are subject to a challenge. If the evidence is that this board and Mr. Tamba had access to form 2 and page 2 at the time that you made your hearing, again, in my opinion, he would not meet the criteria for a motion for reconsideration. And there is the doctrine of finality. Independent of what I just said, there is a need for a decision to be rendered and finalized when it comes to an election matter, especially when there is a primary involved. This candidate is running for the Democratic Party nomination for the office of Secretary of State. And he was provided with a hearing on July 25, and the board ruled at that time. There are a number of deadlines that flow from the deadlines of filing your nomination papers and getting the signatures accepted or rejected. It's a ripple effect, and each one pours into the other. In fact, at this stage, we're already in the period of time that overseas voters should be receiving their ballots, the 45-day period, and that's a federal requirement. So for all of those reasons, both finality as well as whether the motion to reconsider should even be heard because the criteria are not met, I would recommend that we hear from Mr. Tampa briefly on that question, maybe from Mr. Nunes on whether he understands that Form 2 was actually in the possession of the petitioner at the time we heard the case in July 25 and go from there.
That would probably be the first question, do you think, Mr. Ocasio?
I believe that would be the initial
Mr.
question.
Nunes, would you mind coming forward again?
I'm already sworn in.
You are
Yes.
indeed.
So the question is if Mr. Tamba was in possession of, I can't speak to if he was in, of that. I know he was in possession of every form that he submitted to the Secretary of State's office. As I mentioned in the previous meeting, everything that the Secretary of State had received from the local boards, we had received. I believe Mr. Tampa had gotten some photocopies from the Secretary of State where he was missing 2 forms. However, we were provided by those forms in our versions from the Secretary of State, the original versions. We did provide him with those copies at the hearing. To my knowledge, we did provide him with what he was missing in his copies, but my staff was in possession of the original, so they had the set in its entirety.
Weren't those forms 48 and 49 or
I
thereabouts?
believe that's correct, yeah.
47 and 48.
Yeah.
47 and 48.
Okay, thank you. We'll hear from you, sir.
Your Honor, I would like to first disagree with the council's analogy of me being in possession of information when my hearing was heard on the 25th.
Is your mic on, sir?
Yeah, can you just put it closer to you?
Yes,
We
okay.
can't hear you very well.
I pointed out to the board when I was here for my hearing on the 25th of July, not just to the board, but to the Secretary of State office, that Form 2, page 2, signatures were not validated. They were not counted towards the number of signatures awarded me, nor were they included in the number of signatures up for review. But for some reason, my plea went unheard. So that's where the board based its decision on the original count that was provided them by the board staff, that I was awarded 472 signatures. I needed 28, and I had 26 up for review. That fact did not change, even though I pointed out that there were signatures on page 2, on Form 2, page 2, that were not reviewed, not validated. So even though I had the information, but I pointed that out to the board, but for some reason, that plea went unheard. So that's one aspect, that my plea went unheard, and the signatures on Form 2, page 2, were not, if they were reviewed or counted or validated, the count was not added to my signatures awarded me, nor were they added to the signatures up for review. So even if there were two signatures validated, it would have been either 474, and I needed 26 more, and I had 26 signatures for review. That's the first basis. If if two signatures on form 2, page 2 were identified as valid signatures and they were up for review, they would have increased the number of signatures up for review to 28. And I needed 28. So the board would have gone into the process of reviewing the signatures. But the board drew a conclusion based upon the premise that I needed 28 and there were 26 signatures up for review. So that's one. So council, even though I had the information, but I pointed that out to the board and it went unheard. Even the Secretary of State office, Mr. Rock, can attest to that. When I got the forms from the office, I took them up for review. When I flipped the first form, second form, page 2, I discovered that the signatures were not validated, and I called him, and he said, yes, it's true, it's an error. So, and then going deep dive into the forms that I picked up, I realized that I did not just have 26 signatures up for review, plus the 2, but in fact, it was 38 signatures, because there were some names that were coded as not registered, which of course I found that from the Secretary of State database, voter registration database, that in fact these voters were registered with voter ID number assigned to them. And there were some voters that were also coded, not found. And I found that these voters were in fact registered and have voter ID numbers assigned to them in the right city, signed the right form. So I believe these findings are valid to request the board, the honorable board, to reconsider their decision in my case. So I will rest my case there for a moment, Your Honor. Madam Chair.
Thank you. Anyone have any questions of Mr. Tamba?
Madam Chair, I wasn't here on the 25th, so I don't think I can move to reconsider or not reconsider because I wasn't part of the original vote.
Madam Chair,
That's interesting.
did you have an opportunity to meet with Mr. Nunes the last meeting to go over the signatures?
No. What happened is that when the board rendered a decision, and I contacted Mr. Nunes, he provided me with information as to the process, the procedures to filing a complaint, which I did. And I provided Mr. Nunes with the supporting documents, my finding that I had 38 signatures, not 28, as was initially presented to the board. I sent a copy to the council. I sent a copy of that information to the executive director here. Mr. Nunes also, I believe, has a copy. If I can submit a copy to the board for the record, I do have copies here to submit to the board for the record.
Yeah, that can be marked as an exhibit, your exhibit 1.
Exhibit A.
That would be fine.
I don't. So we have just this one? Yes.
I can circulate it.
Oh, I have a couple of other copies.
Oh, I see it. It's actually attached to what,
We all have copies.
Oh, okay.
You're fine. Thank you.
All right.
Yes, yep.
If I could just speak to the matter on the first item that Mr. Tamber spoke to, that, to my knowledge, that matter was clarified at the last meeting at his hearing, where he indicated that page 2, Form 2, page 2 was not validated by the local board. We indicated to him that my staff had identified those signatures and had presented them, 3 of them, for staff, for the board to review. The others that were on here were not validated by the staff. So 3 of these were actually ready in the presentation for you to review if you chose to do that at his last meeting. So that issue, his first item that he addressed, was resolved.
Well, I don't think it was resolved, because if it was resolved, if they had identified 3 signatures, additional signatures to be reviewed in addition to the 26 that were originally submitted, then that would have made the number of signatures up for review to 29. But since I went into deep dive to make sure that, in fact, what I'm finding is somehow, curious, I decided to look further. So I went and then found out that there were some voters who, this comes to the point of disenfranchisement of voters. If somebody gave their signature in support of somebody's candidacy and they are coded as not registered, when in fact they are registered, they have a voter ID assigned to them, why shouldn't their signature be considered? If somebody is coded as not being found in the system, and in fact they are found in the system, why can their signature be considered for review?
The way I understood it, we were told that information, and all of those signatures were reviewed by your staff, correct?
They were, and the 3 that he mentions were included in the.
And they were included in the count.
In the count, which were available for you to review.
I think if I could just clarify this, because I don't mean to suggest that Mr. Tamba does not have a meritorious claim. That's his right to make that assertion. This is a different procedural matter we're talking about, which is the need to have a hearing, make a decision, and then get the ballot finalized. Now, if the board made an error, and I don't believe it did, but certainly, Mr. Tamba, that's your right to make that assertion that the board made an error in the way that it reached its conclusion back on July 25. You know that there are other remedies that you had available. We're now many days, 15 days past that time when this board met and heard and denied your claim. And it's a matter that of urgency that such a thing be. If you think you have a right, you can pursue it, but not before the same board and not with the same evidence. If we made an error, I don't believe the board did, but if we did and a court says we did, that's different. But that's really not for us to consider at this time based upon what the board already had in its possession on the 25th.
Well, I just don't believe that the board made an error. If the board decides to go with its decision, then it means that the board is endorsing disenfranchising voters who give their signatures willingly in support of my candidacy. Is that the grounds that the board wants to really maintain, that they are willingly in disenfranchising voters, or the board role is to ensure that every vote counts? And every voter intent must count as well. Isn't that the board's role and
I think that's
purpose
what the
here?
board has been trying to do all along, no matter who's come before us.
Right.
That's what we are supposed to do. That's what we did do. And in your case, we did that also. All right. And you may not agree with the decision we made, but it's a decision that the board made collectively based on the evidence that we heard. Right? And you say we're disenfranchising people. I don't believe we are, because we're listening to every complaint and we give, to the best of our ability, we're giving a verdict that we think is fair and just.
So, Mr. West, you listen to your board staff that provided you with the information. So if you were listening to my presentation, you would have also recognized then and considered the signatures that were discovered on Form 2, page 2, that day. Because you want to listen to your board staff that provided you with the information, you did not, bother to listen to me. That's what I'm saying. Because if you had listened to me and Mr. Nunez said that the signatures on page 2, of Form 2, page 2 were included, they were not included in other numbers because the numbers that he is referring to were the original numbers that I received from the Secretary of State office. So that finding
You
when
had
I.
that information when he gave it to you, correct, here at the meeting? You had that information in your
I
hand?
provided the information to Mr. Nunez. I provided the information to him. And Mr. Rock here can testify that I call him when I pick up the pile of my forms from the Secretary of State office. And immediately I recognize the indifference and I call him. And I said, Mr. Rock, Form 2, page 2, signatures are not validated. They are not reviewed. And he looked it over and he said, that's correct. It's an error. Definitely we'll get our people on it. But whatever happened, the count of those signatures, if they were reviewed, were not added either in the number of signatures awarded to me or to the group of signatures that were up for review by the board. None.
Mr. Nunez, do we add those figures in, were those figures in his final count?
From the Form 2, page 2, they were, yes.
Thank you.
Mr. Thomas, do you have any additional evidence that was not presented at that hearing, July 25, that you could present today?
Well, I just gave my finding of additional signatures that were disqualified because on grounds that they were not registered voters, which of course they were registered.
You had those forms on July 25 from the Secretary of State's office, the nomination forms, all these.
Say that again?
He had all these forms from the Secretary of State's office on July 25 at the hearing. We went through all those signatures, the staff went through all those signatures. Okay, now we can't relitigate what happened on July 25. So the point is, if you have any additional new information that was not presented or in your possession at that time that you'd like to present.
Well, I just presented the information that you are looking for. I just told you that.
But the information you presented is a spreadsheet from the information that you pulled out of these nomination papers. That's not additional evidence.
Well, the additional evidence is that I used the State Department voter registration database. I think I mentioned that the other time that I purchased the database to do some analytical work for my campaign. And when I had to look up these voters that signed my nomination forms, I went to that database. So that's how I was able to identify that the voters that signed my forms that were considered not registered or not found were in fact registered and were in fact on the database. And they have voter registration IDs assigned to their names. Isn't that new information?
But unfortunately, you just have a 2-day window to do that. We're bound by the statute. Yeah, we're a creature of the Rhode Island statute. The General Assembly's laid out the rules. We can't change the rule.
Well,
It says 2 days, and that's the 2 days. We can't come back and say, okay, I think we should make these changes. We don't have that authority
well,
to do that.
You just heard cases that were heard the same time mine was heard, and you had cases that was heard on the 3rd, and you just heard those cases, and you also will be hearing those cases. So, but for me,
Well, those, Mr. Tamba, those involve a ballot being produced for the November election.
Right.
Yours is for the September primary, and that's all the difference. We have very hard deadlines. That's why we heard those on the 25th, because we had no choice. This board had to make a decision at that time. You may not have been happy with the decision. You expressed that certainly, as is your right. But the board, I don't believe should be considering other signatures that could have been presented on the 25th. It may be unfortunate, but there is a need of finality. The decision that you made, unless there's newly discovered evidence or some other type of excusable neglect, that should stand, in my opinion.
Ray, just again, on the not on the motion, but on his process, he did have an additional process to challenge this board's ruling, correct? This board's not the final arbiter of election matters. He could have gone to the courts, correct?
He could have he could have appealed this decision. That's correct. Whether, when you say, frankly, it's discretionary amongst but it is a right to at least file that, and it's up to the court to decide whether or not to take it.
He could have requested cert, basically, right?
That's correct.
So based on what we're hearing from our attorney, does the board wish to take an action at this time?
So before you take an action, I just want to say that if the board decides to go with their decision, I would like to say that I am being treated with indifference, and that you are not making decision to empower people to be able to participate in the electoral process, but instead you are supporting the idea of disenfranchising voters that vote willingly, provided their time and their signatures in support of my candidacy. And obviously, I might go to the press with this. That's the only option. Instead of going to the court, I might go to the court of public opinion. That's all I can say right now. But I think the board is making an error if they decide to uphold their decision, because you were provided the information, you didn't consider it. You consider what your staff told you, and that's what you stuck to. The number never changed for you, even though you were provided with new information, but the number never changed.
Thank you, sir. You've made your point. Do we have an action the board wishes to take at this time?
First of all, we never disenfranchise anyone. So if you make an assertion like that, it's wrong.
Well, that's true.
So, Madam Chair, I move that we reject his challenge to the process here.
Previous ruling.
Yes.
Motion to reject the challenge of our previous ruling. We have a second to Mr. Schultz's motion, seconded by Mr. West. Any other discussion on the motion?
Well, just from an observation standpoint, just so that you know, this board has done everything it can to ensure that everybody's franchise to vote is respected and that everybody gets the opportunity to vote. So I agree with Commissioner Scholes that this board never disenfranchises anyone. The fact that they've even had this hearing indicates their respect for the voting process. So I just throw that out there, and I know I can't vote on the motion anyway, but I like to say that. And I say that from both sides, because I've been before this board sitting here, and I've been before the board sitting out there as well.
Thank you, Mr. DeSimone. I will say our record speaks for itself.
Can I just make a quick comment? And I appreciate you presenting more information. I also would like to remind us that, the staff did create another document actually that outlines, based on your spreadsheet that you have provided, actually line by line, some of the issues with it. And so while you might have found that there were registered voters, there were several other issues with their signatures. And so I appreciate you did a lot of work to get signatures, and hopefully, but thank you for being here.
Thank you. So no further discussion. We shall vote. Those in favor of the motion signify by saying aye.
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 Those opposed? And we have an abstention, 2 abstentions. And I'm in favor of the motion as well. So the motion carries. Next item on the agenda, we go back to Item number 2, the board may vote to meet in executive session pursuant to Rhode Island General Laws 42455, subsection A4, concerning an investigative proceeding regarding allegations of criminal misconduct. Do we have a motion to go into executive
Madam
session?
Chair, before you do that, I think that the director would like to.
Oh, I'm
address
so
the-
sorry. Did you want to say something?
No need to apologize. My suggestion would be that we continue item number 2, which has now become item number 9, because we're meeting next Wednesday at 2:00. We'll hear that item at that time.
I think that's a very good suggestion. We all agree.
I know you want
I
to go home.
agree.
I know you want to leave.
It's up to you, Madam
So
Chair.
that
You're the-
being
you're-
said,
you're-
we're
you're
continuing
the head of
this.
this group. so
We're
it's up to
continuing
you.
this matter to next week, and we need a motion at this point to adjourn this meeting at 6:16 PM.
So moved.
Moved by Mr. Schultz, seconded by Mr. West. Any discussion? Hearing none. All in favor signify by saying aye.
Aye.
As opposed, we are adjourned. Signed, yep. Yep.